All right, legal considerations for telemedicine abroad. Hello, everyone. I'm David Holt, managing attorney here at Holt Law, the law firm built for healthcare businesses. We frequently receive questions regarding the detailed legal environment of providing telemedicine services while outside the United States. It's a critical area, especially with the rise of digital health, and one that requires careful thought on various regulatory frameworks. The core of the challenge lies in understanding jurisdictional boundaries. For physicians, the allure of practicing while traveling is clear, offering unparalleled flexibility. However, this flexibility is limited by many regulations. Let's break down the key legal aspects. So, first, licensing. Regardless of your location, the fundamental rule is that you must be licensed in the state where the patient is physically located at the time of the consultation. So if your patient is in California, you generally need a California medical license. This could be a full unrestricted license, or in some cases, a specific telemedicine or telehealth license. What's often overlooked is that the state where the physician is located may also require a license if you are deemed to be practicing medicine within its borders, even if the patient is elsewhere. These dual requirements can become quite involved, and state laws are continually evolving. Staying updated on these changes requires careful monitoring of medical board regulations in both the patient's and the physician's states. Next, let's talk payer considerations. Who is paying for the service? This is where significant legal distinctions arise. So let's start with if the payer is the patient. So we're talking about cash pay, self-pay, or the direct care model. If the patient directly pays for your services, for example, cash pay, direct primary care, concierge, self-pay, then your physical location generally has fewer direct legal restrictions, provided you maintain the necessary licensing for the patient's state. In this scenario, you are primarily accountable to the patient and the medical board of the patient's state. This model often offers the most flexibility for a globally mobile practice. Number two, if the payer is the insurance company, so commercial, Medicare, Medicaid, this is where rules become much more strict. Federal programs like Medicare, Medicaid, and TRICARE typically require the provider to be physically present within the United States at the time services are rendered, if you intend to bill them. This is often stipulated in the enrollment agreements you or your practice sign. Commercial insurance companies may also impose similar requirements, though their policies can vary widely. It is absolutely crucial to review each commercial insurance contract to understand its specific stipulations regarding provider location. We often see in the US healthcare system that commercial payers will adopt practices similar to Medicare over time, so vigilance is key. Contractual obligations and malpractice insurance. If you are employed by a telemedicine company or work as an independent contractor, you must thoroughly review your agreement. Some companies may grant temporary permission for you to work abroad, but this internal permission does not override federal billing regulations or state licensing laws. It's also vital to confirm that your professional liability or malpractice insurance provider with whether your policy covers services rendered while you are physically outside the United States. Many policies have clauses limiting or excluding coverage for services provided internationally, even if the patient is US based. Residency and long-term practice abroad. Relocating permanently or for extended periods of time outside the US while attempting to maintain US-based telemedicine work introduces further legal and tax issues. Issues around employment eligibility, tax residency, and the applicability of US labor laws become significant. Companies employing or contracting with individuals who are no longer in the US may face substantial legal hurdles regarding compliance, benefits, and international tax treaties. Also, consider the use of virtual private networks or VPNs. A common question involves VPNs and whether you should use them to mask your physical location. While a VPN can make it appear as though you are logging in from a US state, relying on this to circumvent regulatory requirements is a risky strategy with serious legal consequences. In the event of a complaint, a malpractice claim, or investigation, authorities can and will trace IP addresses. If it's discovered that you intentionally misrepresented your location, even with your employer's informal permission, It could lead to accusations of fraud, breach of contract, professional misconduct, and potentially jeopardize your license or professional reputation. Honesty and transparency, even when challenging, are always the best legal course. Handling the situation. So, given these challenges, my advice is to proactively address these issues. 1, direct communication. If you're employed by a telemedicine company, engage in open and documented written communication with them regarding your travel plans and their policies. Obtain any permissions in writing. 2, contract review. Have all your employment and independent contractor agreements reviewed by legal counsel focusing on healthcare law. 3, malpractice policy review. Contact your malpractice insurance provider to explicitly confirm international coverage and what their policies and rules are. 4, consider the direct-to-patient models. So for those seeking maximum flexibility, exploring and establishing your own direct-to-patient telemedicine practice can offer greater control over your operational parameters and compliance requirements as you sidestep many insurance-based restrictions. The landscape of telemedicine and international practice is constantly evolving and expanding. It is not an easy answer, and there's no single solution that fits all scenarios. Legal counsel is vital to make sure you follow the rules and reduce risks. At Holt Law, we focus on helping healthcare professionals understand and work within these regulatory environments. If you have specific questions about your practice or contracts, please don't hesitate to reach out for a consultation. Thanks for watching, and go to djholtlaw.com to subscribe to this channel for more information. Thank you.